you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point in time. We're not going to argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said.
Yes.
I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How can something, I'm not trying to be obstruction, but how can something be attorney-client privilege and happen before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't.
I'm trying to get out.
Well, that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you turn around and you say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
But they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any space, Mr. Steele.
I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashleigh Merchant is here. She's the president.
Okay, all right. Well, we'll let Ms. Merchant in. That's fine.
Ashleigh Merchant.
Yeah, Ashleigh Merchant.
Ashleigh Merchant, yes. Right, Ashleigh Merchant is present.
All right. Ms. Merchant, good to see you as usual.
I had, 24 lawyers, paralegals with me, all of us ready to fight for Brian. And they denied us admittance. So I wasn't even allowed in the courtroom. We were, that photo that you see, I was outside the courtroom. We were watching it on live stream, knowing what's going on, demanding entrance, and the deputies wouldn't let us in. Finally, Brian Steele said, let in Ashleigh Merchant, she's my lawyer, and they let me in, but they wouldn't let anybody else in.
What's going on, guys? So I did a video a couple days ago about this YSL Young Thug case where basically they're trying to charge him for RICO out here in Fulton County, Georgia, my stomping ground. So this whole thing has gone totally off the rails. So this judge is one of the most corrupt judges that I think I've ever seen. So this guy, if you haven't watched that previous video, you definitely should, though, of course, it's going to be covered here as well, but it's going to be kind of the Cliff Notes version with some new things, because this judge basically was caught red-handed working with the state prosecutors, the DA's office, Fani Willis's office, in order to essentially do what appears to be coerce the key witness into giving testimony that they did not want to give. Okay, so this witness basically historically didn't really want to testify, and it looks like they just were trying to privately coerce this witness in something in a meeting that was called an ex parte meeting. Now, from my understanding, meetings like this can take place, but they have to take place including the defense as well. So the problem here is this meeting took place and it was like a secret meeting with, again, the judge, the witness, the DA's office, which is the state prosecutors, okay? Then you also had the defense just on the side, not privy to it whatsoever. The whole point of not having those meetings privately is so that you cannot do things to intimidate witnesses or to tilt things in the favor of one side versus the other. So it'll be the same way if the defense had an ex parte communication with a witness and the state prosecutors didn't know anything about it. It will be the exact same thing. Neither side can do this, is the point, okay? And the judge, instead of being focused on the substance of the conversation, because, again, the judge was a part of this, since he was busted red-handed, he got all salty and upset and started hammering the defense attorney, trying to figure out, hey, how'd you get this information? The defense attorney refused to budge, and he was therefore arrested. As a matter of fact, he was literally ordered to do up to 20 days in jail only on weekends, meaning that every weekend, instead of looking forward to the freedom that we all look forward to, work throughout the weekend, you get to be a little bit more free. This guy's looking forward, like dreading the weekend, because he's basically getting sent to jail every weekend and somehow still expected to do and control this case for Young Thug. Doesn't make any sense, and it's a whole mess. I don't want to spoil everything because there's some more details coming up here, including some breaking news. So it's probably in the title thumbnails. You probably already know what it is, but if you want to get that info, stay tuned.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt.
The judge in Young Thug's RICO trial orders the rapper's attorney to jail for contempt.
How did you get that information supposedly from my chambers? Did somebody tell you?
You should have told me.
You got 5 minutes.
This happened after lawyer Brian Steele refused to tell the judge how he found out about a meeting between the judge, the prosecutor, and a state's witness. Steele's lawyer is here with what's next for him and Young Thug's trial. I'm Anjanette Levy, and this is Crime Fix. It was a crazy, wild day in court in Young Thug's trial. On Monday, it started with testimony from Kenneth Copeland, who goes by Little Woody. Copeland wasn't really into testifying, despite being given immunity by the prosecution. He spent the weekend in jail after refusing to testify on Friday. Copeland took the stand on Monday and let it be known that he wasn't going to do it.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Steele let the court know that he found out that Judge Earl Glanville, prosecutors, and Copeland with his lawyer met in chambers without members of the defense teams, including Steele, present.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
Can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation.
Before he continues here, I just want to point out that they literally said this meeting was supposed to go from 9 to like 11. Like, so you're talking like hours worth of them having some sort of conversation with this witness that they did not tell the defense about. Now, to say that, well, we didn't talk about anything bad and you just got to trust us. I mean, how freaking dumb is that? Like, come on, guys. Like, if you got such a high profile case, the best bet is to not bend any rules, certainly not to break any rules, because otherwise the case is just going to be thrown out. So it's just a stupid decision to begin with. You see how this whole thing has been derailed because it is? If they would have never had that meeting, this would have never happened.
How did you find out about any of that?
Now, this seems really unusual that a judge would be meeting in chambers with a state's witness and the prosecutor without a member of the defense team there. But Judge Glanville was furious that Steele found out about the meeting in chambers.
So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then,
answering that question. That's attorney-client privilege information. I am not answering that.
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me
don't
who
have to.
if you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly
answer
from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Linville actually ordered that Steele be thrown out of court for the day over Steele's objection and the objection of his co-counsel.
I'm
actually laughing because
Linville actually
if y'all
Did
didn't
somebody
catch
tell
this,
you?
if y'all didn't catch this, like this lady, like peep the black lady in the middle, okay? Like just peep her reaction when this happens. Like that's why I was laughing at, in case y'all was curious.
No, you should have told me.
You got 5 minutes.
Linville actually ordered that Steele be thrown out of court for the day over Steele's objection and the objection of his co-counsel.
Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who
cannot
raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
The prosecutor on the case, Adrian Love, said there was nothing improper about what happened with this ex parte meeting in chambers regarding Kenneth Copeland being held in contempt.
Again, how stupid is it? We just supposed to take her on her word? Like, come on, bro.
Certainly have the right.
If it's not improper, why not just have the defense there to avoid this problem to begin with? The fact that look how defensive they're acting about this. Like, come on, guys. Like, you got to be freaking born yesterday to believe these people.
To request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Now, it seems like even the prosecutor thought that this could be an issue. Adrian Love asked that Steele be allowed to return to the courtroom.
We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial.
Now, later in the day, and I mean the evening after 7 p.m., attorney Ashleigh Merchant came to court to represent Brian Steele in this contempt matter.
Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
Okay.
Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you're a witness to the proceeding.
Argument from Merchant didn't matter one bit. Judge Glanville held Brian Steele in contempt.
Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCGA 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt.
Every weekend.
Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court.
Now, after the judge said that Brian Steele was going to have to spend his weekends in jail, Steele had just one request.
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, sir, if that comes to pass, you have my
Dude, there's no way that you could like seriously work on a case. Like, okay, you got all your case files, you got your computer, and you got your ability to communicate not only with your client, but others who are possibly involved as well. I mean, dude, it's just not the same thing. Like you didn't really have the internet. I don't know if do they give them computers in jail? Like, I don't know.
I support. I will talk with our sheriff and we may be able to make that work. Okay.
And this entire thing has turned Brian Steele into a hero of sorts among defense attorneys. Joining me is Ashleigh Merchant. She is Brian Steele's lawyer. She's also the president of the Georgia Association of Criminal Defense Lawyers. So Ashleigh, talk to me a little bit about how you end up at the Fulton County Courthouse last night at 7:30 at night, representing Brian Steele in this issue, this contempt matter.
Definitely not how I imagined my day beginning or ending.
Right.
I was in a meeting and my paralegal came in and said, your phone is lighting up and Brian's in custody. And I said, oh my God, call me on my phone. I'm getting in the car. I'm driving down there. And, you know, I've served for many years as GACTL, as our association's contempt attorney, where we have attorneys that we dispatch if any lawyers are ever held in contempt. We call it Strike Force. So I'm a member of that. So I'm one of the lawyers that regularly would represent someone. But when I heard Brian was in custody, I had to go myself. And luckily, he's very loved in our community. And so many members of our team went down there and were there. And so we had a very strong showing of force, but it was definitely something I did not expect to happen.
You're a criminal defense attorney and you've done a lot of murder trials. Is this unusual? Because it sounds unusual to me that a judge would meet in chambers with a prosecution, you know, the star witness for the prosecution,
It sounds illegal.
the star witness's lawyer, and they'd all be there having a confab together without a member of the defense team present. Is that weird? That seems like an ex parte communication or something.
Right. And, you know, during my hearing, the judge is admitting that he had this ex parte communication. And it seems like that should be what everyone's focused on, not whether or not Brian is going to tell him who told him the judge had this ex parte. It just seemed like deflecting. You know, the judge was in trouble, got caught with having this ex parte hearing. And instead of admit to that and handle that, you know, when Brian brought it up, they're going to throw Brian in jail. It didn't make a lot of sense. But like you said, it's unheard of. These proceedings are supposed to be what we call adversary, where all the defense is there. The defendants, the defense lawyers are all supposed to be present, but instead they chose to have this meeting without inviting any of the defense, without letting them know. And when they brought that up, the lawyer ends up in custody.
Guys,
time I've
this is just a waste of time in terms of Fulton County, like resources. This is one of the reasons I can't stand the way this place is run, because they're going to go through this trial. It's probably going to take forever. A lot of people are predicting it's going to take to the end of the freaking year. It's like, we're not getting anywhere. The case is even if there is a guilty verdict, it's gonna be appealed and thrown out because of the case is being improperly handled. Like, you got people going to jail, you got private conversations being happening. Like, I seen something about a juror was like recording the case on their phone. Like, I'm like, bro, it's just so much stupidity happening in this case. It's just pure foolery, okay? It's hooliganry, and I don't like it.
Ever heard of a defense attorney maybe being back in chambers meeting with a judge without the prosecution present or something like that happening is when it was like, oh, judge, we need to talk to you about funds we need allocated for an expert or something like that. If it's like a public defender case or something, you know, that's the only time I've heard of this type.
I ain't never heard about nothing that where you to go talk to a key witness in an ex parte communication with the prosecutor and the judge, unless the intent is to intimidate the witness. Point blank, period.
Thing happening. But this just sounds hinky. So what are you doing for Brian now? Because Brian, as of right now, is supposed to report to the jail Friday night to spend his weekend in the cell with Young Thug, getting ready for court and doing his time for this contempt that you argue shouldn't be serving.
Right. I mean, there's two huge issues there. The first, what we're doing is we are appealing it. So we're filing an emergency appeal. Thank God we have an emergency process in Georgia to appeal contempt orders. We believe the judges of the appellate courts will grant a bond. And so hopefully Brian will not have to spend his weekend in the jail. The worst part, though, is this trial is continuing. And so imagine, you know, we don't just work during the hours you see us in court. When we're in court, we are regularly working after hours. We're working at night. We're working on weekends. I have never tried a case where I didn't work all weekend. And Brian is a very good lawyer, and he does a lot of work on his cases. So he's definitely working all weekend. You're taking a man from his office where he has computers, Westlaw, internet, all this stuff, access to the case file. And this case file's huge, and putting him in a jail cell where he's none of that. That the trial can't continue. I mean, it's just, it boggles my mind that anybody thinks that you could have the lead defense lawyer in custody the entire weekend and this trial continue unhinged. That defies logic to me.
So you're filing the emergency appeal. I mean, I would assume you expect to hear back about that within a day or so. Am I wrong about that? Or what's the process? What's the time frame?
Yes. Luckily in Georgia, when an attorney is subject to incarceration, the appellate courts respond very quickly. And what it's called is a supersedious bond. So essentially they issue a bond that kind of stays everything and says, wait, hold on, we're going to pause this. You're not going to have to go to custody. You get to go and do this appeal. And so it just pauses that while the appeal is pending. If we're successful with the appeal, then Brian never has to go into custody. Obviously, if we lose the appeal, he could still be forced to spend weekends in custody, but that would be down the road. That wouldn't be right now.
But then we have the issue of this big kerfuffle. I mean, this big mess, this big confrontation between the judge who seems very angry and really dug in on his position, and Brian Steele. Now the trial continues and they have to move forward. Brian Steele moved for a mistrial. That's not happening. Can this trial continue in your view and be tried fairly given what's happened? I mean, it doesn't matter if the jury didn't see this. It's something that is impacting the course of the trial.
I mean, the whole thing that the way that they try to cap with the jury, it's like, bro, what, they didn't got TVs at the house? Like, the jury juries aren't like forced to sleep in the freaking courtroom like it's like some sort of freaking camp. They go home every day, so they know what's going on. Family, friends, you know, people are telling what's going on. They can just look at the TV, get updates on their cell phone, everything.
Defense lawyer, nothing will affect your advocacy more than a judge saying, if you keep arguing and doing your job, I'm going to lock you up and putting you in handcuffs. Nothing. will affect you more. And that's essentially what happened. Brian made an argument. He ended up in handcuffs. He ended up in the Fulton County Jail in the lockup for, an hour or so before the judge let him out. Nothing will stop an advocate in their tracks more than going to jail, because you can't do your job. And, that fear has got to be in the back of everybody's mind in that courtroom. Every single defense lawyer, some of them, they may have kids they've got to go home to, and they can't go to jail. I mean, you think about the things that are going on in their minds. You want to be able to do everything you can for your client, but you can't do that if you're in jail.
But Ashleigh, can he go to the appellate court? Can Brian Steele maybe go to the appellate court and say, look at what happened? I mean, it's on video. That's not how appellate courts make decisions, but it could be filed as an exhibit and file something saying this is, some type of an appeal saying, what is going on here? What happened is impacting this trial. Can that happen?
Oh, yes, definitely. And I was doing some research this morning working on this appeal, and the law is really clear. If you have an ex parte communication with a witness during trial, it is reversible error. So this error is, and what that means in the legal world is that's about as bad as it gets. That means it's reversible. That means that any conviction is going to be reversed because of this. So if they want to try and remedy this, they better hurry up and remedy it. And the state should really be thinking about that, because the state's duty is to preserve their conviction. So if they were to get a conviction, they have a duty to make sure that the conviction stands on appeal. And this is reversible error. So I don't understand why they're not jumping up and saying, give him these transcripts, give him what he asked.
Well, if you recall, the lady was saying, well, can we make sure that, this guy has what he needs to continue being the defense attorney, right? Brian, for Young Thug. But I just don't see how you could say that it was reasonable to expect him to be functioning at his best and giving him the best legal counsel that he could get from a jail cell on the weekends. Like, I don't know, that just sounds like an easy appeal to me.
For in this ex parte, they have a duty to preserve the record as well. Otherwise, they're just wasting the taxpayers' dollars and keeping people incarcerated while they try this case that they know is not going to stand up on appeal if there is a conviction.
Ashleigh Merchant, we'll keep an eye on it. Thank you so much.
Look, and last little update, 'cause I know this video is long already, but look, so the paperwork was already submitted, guys. So bada bing, bada boom. Okay, it says enforcement of the trial court's order is stayed pending resolution of the appeal. So basically the appeal is not fully granted, but it is stayed. It's literally exactly what Ashleigh Merchant said. This lady knows her ish, okay? Like, she got Nathan removed, okay, out of Fani Willis's BS conflict of interest, appearance of impropriety, motion to dismiss, because she shouldn't be nowhere near the law. No way. Y'all saw how crazy that lady was, and this is her office is screwing this up right now. That's probably why this whole case is so jacked up, because these people is Fani Willis's people. Okay, none of these people know what the hell they're doing. That's why this case is so screwed up. Like, that's why they throwing people in jail and they having private communications to intimidate. This is above these people's mental capacity. Okay, they're not at that level yet. They think they got their law degree and worked in law for a while. All of a sudden, they felt like they was experts. They got too ahead of themselves. They got too arrogant. They just had too much hubris and pride going. And you know the saying, pride comes before the fall. Okay, so you done screwed up the Trump case. Like, who knows if that's ever gonna go forward or finish or anything. And then you also screwed up, in my opinion, this case probably should have been a damn slam dunk against Young Thug. You managed to screw that one up too. So congratulations, Fani. You played yourself. Drop a like on the video. Subscribe to the channel if you're new. I appreciate y'all watching the Black Anomaly Rising channel. I'm out.
He's incarcerated because he wouldn't testify. He pled the fifth. They take him back into chambers and have a conversation that all reports indicate was probably a pretty heated conversation, where he said he didn't want to testify, and they explained how long he was going to have to spend in jail if he didn't testify. And then after this meeting, immediately this witness all of a sudden changes his mind, isn't pleading the fifth, and starts to testify. And so Mr. Steele wanted to know what happened during this hearing, but instead of addressing that, all Judge Glanville cared about was who told on me.